big breaking news coming in. This is related to the pleas regarding or against the abrogation of Article 370. The hearing is going to commence on the August 2nd. In fact, the CJI said that they want to ensure all documents and written submissions are in place when the hearing does commence on the 2nd of August. Let's take a live look at what's happening inside the Apex Court.
Fresh submissions, rejoinder submissions. Once submissions have been filed, we have to freeze it at that.
Lordship, please.
So, because, otherwise what happens is right until the last evening, we got a 1,000-page compilation, which means, this is unfair to the members who are appearing, the members of the bar who are appearing. It's unfair to the bench because, we have got ready on the basis of the record as it stands and when the matter is being argued. So, I think everybody must now conform to the discipline of freezing everything before the argument starts.
So your Lordship feels that will not happen.
That affidavit should not then be taken up.
No, I would join the Chief Justice because...
as if 370 scrapping has really benefited, not which then we'll have to deal with it.
But really speaking, Mr. Dave, that affidavit has no bearing on the
Yes, but it can come on record. I don't
it is fun. It's appeared in press very widely today morning.
No, that can't be.
That's for the press, but that's not for us.
Not copied.
फाइल का ये वाली
It is served upon everyone.
We haven't got it. Mr. Mehta.
I'll give you in 10 minutes if...
No, I'm sorry you will give. I'm just saying.
We have received a copy of that.
Just, my Lord Justice Gawai's smile is telling. As I always say, my Lord, bar also takes judicial notice.
He's on the
Bar sometimes, my Lord, tries and read your Lordship's silence.
The latest coming in from the Supreme Court. So the Article 370 case is going to be heard from the 2nd of August. In fact, the CJI basically saying that they want to ensure that all the documents and written submissions are in place by then. Neelashish and Pradeep Datta joining us live on the broadcast. First, let's go across to Neelashish. Neelashish, over to you. Take us through the latest proceedings as far as the Supreme Court is concerned. We believe that the hearing in the pleas against Article 370, the abrogation of 370, are going to be heard on the August 2nd.
Yes, absolutely. Approximately 3 years after the matter had come up previously in Supreme Court, now the 5-judge Constitution bench headed by the Chief Justice has made it clear that on the 2nd of August, the hearings will commence. That is a Wednesday. So as far as the Constitution bench is concerned, they sit on Wednesdays, Thursdays, and thereafter on Tuesdays, as the CJI just said. So the matter will be taken up on these days. Before that, of course, they have said that the compilations that have been sought, that had been earlier sought to be filed with regard to the various petitions. Remember, there are 23 petitions that are before the Constitution bench at this point with regard to the abrogation of Article 370. So now the date of 26 July has been given by the CJI, saying that by that date the parties must ensure that there is a compliance that is filed with regard to various petitions and other documents that are involved. And thereafter, once the documents are ready by the 2nd of August, all these things should be ready, is what the CJI said. So from the 2nd of August, the 5-judge Constitution bench headed by the Chief Justice of India will be hearing these petitions, and from there on they will take it on a day-to-day basis as far as Constitution bench days are concerned in the Supreme Court. So definitely a step forward with regard to these petitions that have been pending for about 3 years now, and now the CJI-led bench will in fact be taking it up from the 2nd of August.
So a step forward as far as the pleas against the abrogation of Article 370 is concerned. Of course, ever since it's been 3 years since those pleas had come up in the Apex Court. Let's dip into the Supreme Court and listen in once again to the live arguments which are taking place there.
May I suggest something, my Lord, which would, my Lord, meet with everyone's requirement. My Lord, there cannot be any reason, my Lord, for anyone on this side to shy away from the facts mentioned post 19. I can make a statement, both of us can make a statement, that would not be a justification for deciding the constitutionality
Then it's not relevant.
involved. But
Then it's
why,
not
why,
relevant.
why, why everyone should
All
not?
right, we'll say this. What we will say, all right, we will say this, that the hearing of the petitions before the Constitution Bench shall commence on 2 August 2023 at 10:30 a.m. and shall thereafter proceed from day to day, except for the miscellaneous days, namely Mondays and Fridays. Full stop. Next. It has been agreed that Mr. Prasanna, learned counsel assisting on the side of the petitioners, and Mr. Kanu Agarwal, learned counsel assisting on the side of the respondents, shall be the nodal counsel for the preparation of common convenience compilations. Full stop. Since convenience compilations have already been prepared earlier, should any of the council seek to add to them, this shall be done positively by 27 July 2023. Full stop. The nodal council shall ensure that the convenience compilations are indexed with the running, are indexed and paginated to facilitate the hearing. Full stop. All the learned counsel shall be at liberty, shall be given copies of the convenience compilation, so indexed and paginated, immediately after the compilations are prepared. Full stop. Once the convenience, full stop, the convenience compilations shall, written submissions shall also be filed on or before 27 July 2023. Full stop. After 27 July 2023, no further documents, no further additions to the convenience compilation shall be permissible, and the arguments shall proceed on the basis of the status of the record as on 27 July 2023. Full stop. The Solicitor General has informed the court that the Union of India, that though the Union of India has filed an affidavit, an additional affidavit, setting out the perspective of the Union government in regard to the post-notification developments, the contents of the affidavit have no bearing on the constitutional issues which are raised in the petitions and shall hence not be relied upon
For that purpose.
For that purpose.
One small, there is.
Even Chief Justice, the synopsis, I think there have been filed
Yes,
all the parties already. So
once again, Justice Call is saying something. Yes, Justice Call.
Permit me to allow you speak.
Just 1 second, Justice Call was saying something because he's online.
in view of the stage which this matter had reached, Chief Justice, the synopsis also had been filed by the parties.
That's right.
So unless they want to supplement it, both sides had filed, at least especially the petitioner side had almost completed argument. So the synopsis were already filed. So they may look at whether they want to rely or, somewhat alteration the same. May not be.
Paul says if you don't want to supplement from...
We need to supplement. There have been subsequent judgments which have come in the last 2 years, which we have to rely on.
That's right.
Supplement if required. So that,
That we've already said now.
At that time, Lords, there are,
Democratic Party.
there are totally,
Lord,
sorry, one.
Lord,
Any additional material which is permitted to be filed by the date so prescribed shall be filed only through the nodal council.
The only concern in asking this kind of indulgence is, I suppose in a matter like this, in the course of an argument, a perception or a perspective on how look at a constitutional provision, or even development taking place earlier or later, how they could be seen in a particular perspective will be matter for the court and the council to assist the court.
Yes.
Therefore, to foreclose everything at this stage would be little problematic. Right?
No, that
Foreclose
let
the
there be a...
documents. That's what I'm saying.
No, only document. Mr. Attorney General, it will become impossible because if people start, filing things, I think this is now, let us follow this as a modality for Constitution Bench hearings, that at least a week before the hearing starts, everybody is aware of what they're going to argue, and then you conclude it it with
Well, there
that.
are 20
All right, only one last thing which I wanted to suggest was this apportionment of time.
Yes.
I think that's very important. I would suggest that on the side of the petitioners, you must sit down together, decide who is going to argue what
Mr.
point.
Ramachandran is leading us.
The order in which arguments should be addressed should be given to us in advance by the nodal council. Likewise, on the side of the respondents. And please apportion time between yourselves. We might do that before we commence the hearing.
On this side also, this side also will.
My lords,
do that so that we can.
13.
We've done it
My
before,
lords,
we'll do that. We have 23
Gopal, just give me a
petitions
minute.
followed in this list, of which 14 of them are the challenges, the 370 challenges. 8 of them are prior in time, which are challenging Article 35A. Those actually can await the outcome of these 14.
Correct.
Because if we succeed here, then those have to be heard. If we fail completely here, then those become infructuous. They are on the list. I have, in fact, broken the copy.
You can hand it over to the court master. And perhaps what you can do is this can be added in the convenience compilation so that instead of now taking
Taking at this
documents.
stage may not, perhaps, my lord,
We have two campaigning petitions.
All convenience
Lord,
compilations
tagging, my lord,
shall be
would be-
prepared. All convenience compilations shall be exclusively in the electronic mode.
Later.
So Army National
There is
Your
an
Lordship,
Mr. Dwivedi, we'll do that. We'll decide that after the matter opens. We'll not do anything like that right now.
if my lords
Your Lordship,
bookmark
Your
13,
Lordship.
just 1 minute.
Army National Congress, the leaders were under arrest at the time the hearings were going on. Finally, they've been able to sign off on the writ petition. We filed that. We have a tidy number. Notice may be issued.
well, let us see, my lord. I do not know. Nobody was under arrest
why don't you do
for
this?
3 years.
It's issues of constitution. Dr. Guruswamy, question of constitutional validity is common in all these matters, or most of them. Give a copy, just give a copy to the
Or
solicitor
she
general.
may file an intervention because to
have-
say that.
Whether we treat it as a petition or an intervention, there is a common counter. Just give a copy to the learned
I
solicitor.
have no
general.
difficulty. I am only, my lord,
There is
perturbed
also
by the
an
fact.
impediment, my lord.
Your-
My lord, I am
My
only,
lordship.
We just told you what to do. Give a copy to the.
I'll take the, I'll take the copy. There is no difficulty.
Taking a copy is not a problem.
Mr. Mehta, just 1 minute.
Inside. That's important.
There's an impeachment by the people.
It is an order, my lord. Kindly see.
Your
It
Lordship.
is a political party.
All right, insofar as the impediments are concerned, please take it that we are not going to shut anybody out like
Very.
this. But everybody will have to ration time.
Yes,
Because once
undoubtedly.
the first 2 or 3 council have argued the matter, then the others know what has been covered, what ground has been covered. We
Correct.
therefore, but time has to be apportioned.
Absolutely,
Otherwise,
but we did it in the same-sex marriage case. We don't
No,
speak
no,
to
no,
what
no,
you have already passed an order.
But there,
Shah Faisal.
but there is only a minute, only a.
There is also.
all right, one thing, the 2 nodal council, Mr. Prasanna and Mr. Kanu Agarwal, insofar as the intervention applications are concerned,
Yes.
please ensure that the intervention applications are also given to the 2 nodal council. You can prepare in the index a separate head for the intervention applications, number, who it has been filed, and the arguing council. So that
Possibly-
ideally, if both
possibly-
of you can tabulate for us what the essence of the intervention is, that will facilitate.
Only one
There's one
aspect.
small housekeeping detail, minutes in the lead petition, in the first petition in which I'm appearing, out of 7 petitioners, 2 petitioners have moved applications to be deleted. Those may be allowed minutes and we'll give the amended cost title. So now 5 petitioners will remain out of 7. The cost title will have to change accordingly. Those who want to be deleted would like to be deleted today, minutes.
What is the IA number? And who are the 2 petitioners? Who are the 2 petitioners who want to be deleted?
One is minutes, Dr. Shah Faisal, the first petitioner, and Ms.
I
Shweta
have an
Rashid.
IAS officer, my lord, working in the ministry. My lord, therefore, my lord, he possibly doesn't want to continue. We have no objection if there are other petitioners, and others can argue.
Number 3, Shaila Rashid. These 2 don't want to continue. 5 others will continue.
IA number ले लीजिए. Numbers
1 and 3.
1 and 3 naam ले लीजिए. Seem to be deleted from the array of parties. The application for deletion
1099.
is not opposed. Full stop. The application for deletion is hence allowed.
And we'll file amended cost title.
The amended cost title shall be filed
Lord.
within a period of 1 week.
Grateful.
Lord, it's my
Your
duty to
Lordship.
bring to your lordship's notice. There is a judicial order passed by your lordships, my lord, in this group of matters, which says the registry is directed not to entertain any other writ petitions on these issues in future. Therefore, I was saying that she may file an intervention. Ultimately, she wants to be heard. Nobody would object, Ms. Guruswamy, to be heard. Because otherwise, there would be many petitions coming, thereafter.
You can treat your writ petition as an intervention application.
Then I'll not oppose the
is that you have to be heard. We'll hear you. And so that in that petition you say.
Otherwise, many more will come. That's the
intervention application and shall be renumbered. I think
My lords,
because otherwise there'll be constantly get new petitions.
My lords, because this batch of cases known as with Shah Faisal's name, because that's the lead petition, it's going to change now with his deletion. I had a suggestion. In these large batch matters, if you can just put it in re the issue, and that can be the heading. This concerns Article 370, it can be in re Article 370, because every time the name changes, very difficult to keep track of where.
There is one petitioner who is already there to request your lordship to treat him as a first petitioner.
That may be different.
Online, fastest finger first, that I filed it first, so it's.
Article 3.
Lord, last time, my Lord Justice called, my Lord very aptly said that you are doing that fastest finger first. You file it first.
We'll call this as in re Article 3.
In re Article 3.
We'll say,
yes,
with the consent of all learned counsel and at their request, the cause title of the proceedings for convenience of reference shall be as follows, into inverted commas, in re Article 370 of the Constitution.
One of the petitions passed to government to file. We may be permitted to file an application.
Bringing?
Somebody has passed away.
One of the petitioners passed.
All right.
They need a petition a bit.
Your Lordship.
Just delete that person.
That's to come in a petition of this nature.
We'll just
Your Lordship.
there is no list. The permission to delete so and so is granted.
The petition would abate. Alas can't come out in a
Your Lordship.
Petition number 2. Just write it down for the court master so we don't make a mistake on the name.
Lordship, I have submission. We filed the intervention application 2019. We want the reasonable time. We also be given opportunity of being.
We've just said that, but the interveners, we will ration time. The two nodal councils shall prepare a list of interveners. So if there are 500 interveners, we can't give everybody time to argue in the intervention application. We'll see what to do.
Freeze the time filing of the fresh petitions, so we file later on the intervention. So
all right, we'll see when it opens up. We'll decide at the end how much time to allocate to the interveners. We'll hear the main counsel first, and then we'll see what to do thereafter.
Very
I think that. 2nd of August. 27th is the day for freezing all the submissions, pleadings, etc., and submissions and the case law compilations. No further pleadings shall be filed, and we have recorded the statement of the SG does not have a bearing on constitutional validity.
Of course not.
Your Lordship, so 2nd we will start.
Your Lordship.
He wants to withdraw an IA.
You want to withdraw an IA?
Yes.
Why? What is the IA for? For intervention. Will you give it to the court master on a slip of paper? So we'll pass an order on that. Intervention dismissal.
Your Lordship, may allow me to. Your Lordship, please allow me to speak.
Yes, Mr. Manohar Lal Sharma.
Your Lordship, this is a petition. Subject matter what I filed first. Notice was issued by the 3 judges bench. Thereafter, it referred to the 5 judges bench, and notice was issued also by the 5 judges bench. Pleading was directed to be completed. Thereafter, one judgment also done for some intervention application. Now you also say my name has been removed, some other name is there. I think this is not fair.
Mr. Manohar Sharma, this is always an issue you are appearing, but now to obviate all this, we have decided to call the proceedings as in re Article 370 of the Constitution, so that nobody feels that he should have been or she should have been the first petitioner. We will. The argument will appear in the report.
Notice was issued in my petition very first day.
Sharma, that date itself, I told you we will not do it like this. So please don't repeat what we had rejected last time. I recollect definitely.
Yes. Your Lordship.
Brother Call, thank you very much for joining in with us online. Take care of your health.
Oblate, Your Lordship.
All right. So the hearing on abrogation of 370 will commence on the 2nd of August. You were witnessing the arguments that are taking place. The court making it clear how it is going to proceed on the hearing. The court has also asked everyone to compile the documents in time before the hearing begins. We have